The next case on the call of the docket is agenda number 21, numbers 126840, 126849, Guns Save Life, Inc., and versus the Village of Deerfield et al. I understand that you'll be splitting your arguments this morning. All right, thank you. Mr. Brian Siegel, are you first?
Yes. Madam Chief Justice, may it please the court. Good morning. My name is David Siegel. I represent the plaintiffs in the Easter Day case. And my colleague in the consolidated case and I are here to discuss two issues which are separate and distinct from one another. However, they do have one thing in common. Both involve the defendant not doing something which it was allowed to do in the time, within the allotted time in which it had to do it. On both issues, the defendant had to reach out to the lower courts for a lifeline. On one issue, the circuit court gave it to the defendant. On the other issue, the appellate court gave it to the defendant. The lower courts were wrong. Now, my colleague will be focusing mostly on the preemption issue, and I do hope to address it as well. But first, I would like to discuss why the Easter Day plaintiffs should not have had to be here in the first place. This is because the appellate court had no jurisdiction over the Easter Day appeal. The appellate court correctly noted in its first appeal, that if the consolidation of the two cases was not a merger, then the defendant's failure to establish that fact was fatal to any appeal in the Easter Day action. Therefore, unless the consolidation below was a merger of the two cases, the defendant could not appeal the Easter Day case. The facts established this was not a merger. Briefly, on June 12th of 2018, the circuit court entered two temporary restraining orders, two TRO opinions, and two orders with two different captions. On July 27th, 2018, the circuit court consolidated the two matters sua sponte. No party asked for it, and no explanation was given as to why. On August 12th of 2018, Guns Save Life filed its amended complaint. 5 days later, the Easter Day plaintiffs filed their amended complaint, both with their own cases, their own captions. On March 22nd, 2019, the circuit court granted summary judgment with two opinions and two orders. It set a future date in the Guns Save Life case, but not Easter Day. Easter Day plaintiffs received everything they wanted from the circuit court. Now, upon information and belief, future proceedings actually did take place in Guns Save Life. But Easter Day doesn't know what they were or what happened because Easter Day had no part in it. As an aside, I only found out about it yesterday. The Easter Day plaintiffs were not a part of anything that went on after summary judgment. Now, what's at issue then is two types of consolidation. The first, and this is from the Bush versus Meissen case. The first is where several actions contain an inquiry into the same event in its general aspects, that the actions can be tied together, but they have separate docket entries, verdicts, and judgment, the consolidation being limited to a joint trial. That's what happened here. The second one is where several actions are pending which might have been brought as a single action. The cases are merged into one action, losing their individual identity to be disposed of as one suit. That did not happen here and could not have happened here. Now, this affects appellate jurisdiction because a regular consolidation that isn't merged has to be appealed within 30 days, regardless of what happens in the other cases. A merger, short of having a 304A finding, a merger can't be appealed until all the cases are disposed of. So what we have here is an issue that probably people don't think about very much, but which turns out to have very severe ramifications. Now, Your Honors, the first form of consolidation is what is correct in this case. The Nationwide Mutual case states, quote, where a consolidation concerns several actions involving an inquiry into the same event with its general aspects and is limited to a joint trial with separate docket entries, verdicts, and judgments, an order dismissing one of the actions is deemed final and immediately appealable. That is what we have here. The Casnell case, separate case numbers, separate judgments, same thing. So the circuit court, however, when asked the question, found a merger. But I submit to the court that the circuit court focused on incorrect factors.
Mr. Siegel, what prejudice did you suffer by the trial court clarifying that its consolidation of the order was intended to, that he's going to merge cases?
Two things. Well, one thing and then a follow-up, Madam Chief Justice. The first, the answer, the prejudice is the Easter Day plaintiffs had won. They received summary judgment. They received everything they asked for. Now we're here. I'm always happy to address you, but the fact is that the Easter Day plaintiffs should not have been subject to an appeal. The defendant did not appeal within the required 30-day time limit. Now, the appellate court asked the same exact question, not of us. They addressed it in the opinion and said there's no prejudice. But the fact of the matter is that prejudice isn't supposed to be a factor in this consideration. When a defendant appeals on day 31, is there really a prejudice to the appellee of defending the case? If the appeal is filed that one day later? No, of course not. It doesn't affect their actual ability to defend the case. But that appeal is going to be dismissed all the same. So there is the part A is that there's great prejudice. Second is that prejudice shouldn't really be a factor in this. I just briefly want to say, and then I guess I'm asking to save the remainder of my time for rebuttal. The circuit court relied on a secret system in the clerk's computer. Well, the clerk's computer really can't process mergers, so even though everything was done that it wasn't to a regular consolidation, this was really a merger. So does that mean every case in Lake County, every consolidated case in Lake County is merged? What happens when Lake County upgrades its computer system? Do all those cases go back to being the other type of consolidation? What about all the other counties in the state whose computer systems might not be up to the technological levels of Lake County? Are all those consolidated cases really mergers, but the parties probably don't know about it? And what happens if somebody assumes that the computer system isn't up to par and then goes and files their appeal late and only to find out, no, actually, we've got a pretty good computer system over here in blank county and we could have done it if we wanted to. It's not a system. It's not a system for making this determination. The parties should not have to be surprised at the end. And otherwise, what's the point? What's the point of all the case law that says what factors to look at? If the circuit court judge can just disregard it and everything that's been done in the case and just say his or her own mind at the end, what's the point of all the case law with all the factors? The last thing I want to say on this issue is that the federal system, as illustrated in Hall versus Hall, says all cases are just consolidated. There's no merger. You want to appeal your case, you have 30 days. Doesn't matter what the other cases, what's going on in them. And this court should take this opportunity to set that standard. It's much cleaner. The parties would know what the heck's going on, and you wouldn't find parties like my clients who are prejudiced because a case that they won at the circuit court, suddenly they find themselves, no, actually, you have to defend an appeal. Unless the court has any questions, I don't want to eat up my colleagues' time, so.
All right, thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. I'm Brian Barnes for the Guns Save Life plaintiffs, and I'm going to talk about the merits of the preemption claim that is before the Court. And our fundamental submission to the Court is that there's a difference, a substantive difference between, on the one hand, amending an ordinance or a statute, and on the other, repealing and replacing the statute. And we see this in common parlance. A few years ago, there was a debate in Congress about the Affordable Care Act, and Republicans said they wanted to repeal and replace that law, and Democrats said they wanted to amend it. And the differing usages there bring with them differing meanings about the extent and nature of the changes that the parties were fighting over. And it's the same here with Section 13.1c. What we see in that statute is a usage of this phrase may be amended that reflects an assumption that an amendment is not going to be a radical policy change or a radical departure from the pre-existing policy that existed at the time and was adopted at the time that the legislature said home rule units could adopt policies that regulated so-called assault weapons. And an important point to note about the statutory text that the Court has before it is that the way the legislature framed the scope of the sort of exception to preemption was around the idea of particular local regulations or particular local ordinances not being preempted. It didn't say that particular jurisdictions were exempt from the scope of the preemptive effect of the statute. Instead, it said that particular ordinances and particular regulations, albeit regulations and ordinances that may be amended, are the things that are not preempted. So it's really the way the legislature framed the inquiry. It's a question not of who, but of what. And the defendants in this case, they want to turn it into a question of who. On their reading of this phrase may be amended, the upshot of it is that once Deerfield enacted any legislation that touches in any way on assault weapons within that critical 10-day period, Deerfield has just carte blanche to regulate in whatever manner it wants. And sometimes the General Assembly does, in fact, create exemptions for particular jurisdictions from the preemptive effect of state law, but that's on the plain reading and the plain meaning of the text of this statute. That's not what the General Assembly did. Instead, they focused the inquiry that courts are supposed to undertake on whether the particular ordinance existed at the time that this 10-day window occurred. And so,
Counsel, in light of your repeal and replace argument, repeal and replace versus amend argument, how do you view the dissent's reliance on the ownership versus possession distinction?
So I think that is a completely independent basis for reversing the second district. The way I think the right way to view this is we basically have three overarching paths that the court could take, and I would submit that any of the three paths is correct. And the first is what I've been talking about, this idea of repeal and replace versus amend. But certainly, I think an alternative and equally viable path, a correct reading of the statute, is to follow what the dissent did below and to recognize that there's a difference between the regulation of possession under this statute versus the regulation of ownership. And one thing on the statutory text specific to that point that I would just urge the court to really focus on is that first sentence of Section 13.1c. It uses the plural rather than the singular, so the language is the regulation of the possession or ownership of assault weapons are exclusive powers and functions of the state. So what that plural is telling us is that the legislature views the regulation of possession on the one hand and the regulation of ownership on the other as two distinct powers. That's just a premise of the plural usage there. And what we know from that plural usage is that in order to preserve both the power to regulate the possession and the power to regulate ownership, Deerfield had to exercise both of those powers within the 10-day window, and it didn't do that. And in fact, I'd point the court to page 26 of Deerfield's brief, which actually concedes in one of the headings. They concede in their brief that Deerfield's 2013 ordinance regulated possession, but it didn't regulate ownership. And that, on the face of the 2013 ordinance, is plainly correct. One premise of the 2013 ordinance, just on the text of it, is that it is possible to have lawful ownership in Deerfield. And all the 2013 ordinance did is it placed modest restrictions on the way people who lawfully owned these firearms could store them and could transport them. And whatever the exact line is that the court draws between possession on the one hand and ownership on the other, I would submit to the court that it's clear that the 2013 ordinance regulated possession and not ownership. Now, the second district, in rejecting the dissent's point of view on this, the majority basically said, well, it's too hard for us to distinguish between possession on the one hand and ownership on the other. And so we're not convinced that there's a coherent line that can be drawn between those two concepts. And so we're going to reject that method of interpreting the statute. And a couple of points in response to that. One is I think this case is actually a pretty good illustration of the fact that it's not that hard to draw this distinction. As I said, the 2013 ordinance, it places these modest restrictions on transportation and storage clearly in the heartland of the regulation of possession, but it simultaneously recognizes that it's possible to lawfully own these firearms in Deerfield. Conversely, what we have in the 2018 ordinances is an across-the-board prohibition on all of the incidents of ownership. You can't possess, you can't buy, you can't sell, you can't transport, you can't do any of these things.
Where in the 2018 amendment ordinance does it ban ownership of assault weapons? Where in the 2018?
So the 2018 ordinances do not use the word own. However, what I would submit to the court is that it's common to think about property ownership as sometimes people use the metaphor of a bundle of sticks. And if you take away all of the rights that are represented by each stick in the bundle, then you've taken away ownership. And that's what the 2018 ordinances do. In
So
other
you're
words,
asking us to read into that, because the words aren't there, read into it as banning ownership.
well, I guess what I would submit to the court is that the inquiry here should be one of substance. We should be asking, in substance, is this a regulation of ownership as opposed to a regulation of possession, rather than just falling back on whatever labels Deerfield's lawyers, insert into the ordinance. If the court were to follow the path of saying, well, they use the word possess and not own, and so that's the end of the inquiry, then this statutory distinction that the General Assembly adopted in the legislature would just collapse. In other words, if Deerfield can just label whatever it wants as regulating possession but not ownership, then I guess just the basic textual distinction that we have in Section 13.1 would become a nullity. And so for that reason, I think that it's important for the court to recognize the substance of what Deerfield has done. And I think, again, just in common parlance, it would be fair to say that it's illegal to own an assault weapon in Deerfield after the 2018 ordinances. I mean, that's the plain effect of the law, even if it doesn't use some magic word. Finally, just a word about kind of the third of our three merits arguments, which is this idea that the first sentence of Section 13.1c completely displaces local authority to regulate in this field. The basic point that we're making here is that by force of operation of Article 7, Section 6H of the Illinois Constitution, that when the General Assembly explicitly says that it's exercising that power, that authority to completely displace local authority in a field, that is the necessary effect of the General Assembly's enactment. And even if there's other language in the statute that suggests otherwise, that is the effect under the Illinois Constitution. Thanks very much.
Thank you, Mr. Barnes. Mr. Wilson?
Thank you, Chief Justice. For the record, my name is Chris Wilson. With me at council table is Steve Elrod, who is the village attorney for the village of Deerfield. And I'll note for the record, a professor of state and local government at Northwestern University. Your honors, and may it please the court, a cornerstone of the Illinois Constitution of 1970 is its strong presumption in favor of home-ruled authority and local decision-making. In 2013, when the General Assembly adopted the Foyd Act amendments addressing assault weapons, they expressly recognized these principles. Specifically, they created a hybrid form of concurrent jurisdiction that allowed home rule jurisdictions to opt to retain their authority. And listening to the two arguments, I think they may have abandoned this argument, but I just want to make clear for the court that the critical factor in the section 13.1C of the Foyd Act amendments is this hybrid authority. It was described as a use it or lose it provision. You had to opt to expressly adopt home rule jurisdiction, or you lost it to the express authority of the state. And the language of 6H is simply reflecting that. If you don't opt in, you have lost it. You have now, the state has assumed complete control over these. But the best starting place for this is the statute itself, which the council has read out entire sections of this. If I could just read from 13.1C to frame our discussion, an ordinance or regulation or portion of that ordinance or regulation that purports to regulate the possession or ownership of assault weapons in a manner that is inconsistent with this act shall be invalid. So the state will have total control unless the ordinance or regulation is enacted on, before, or within 10 days after the effective date of this amendatory act. The statute then goes on to state an ordinance enacted on or before or within 10 days, so within that critical 10-day window that they provided home rule jurisdictions, within 10 days after the effective date of this amendatory act, may be amended. They say it right there. You are not locked in to what we're requiring you to do in 10 days. Just exercise some authority, do something inconsistent with the state's exclusive authority that we're purporting to adopt. Do that, and you now have jurisdiction.
The village couldn't repeal and replace what it had originally done, correct?
Well, it can retain its authority. So it
can say, as long as we're retaining our authority, we're throwing out everything we said before, and we're going to put in a whole new set of regulations.
Well, you're right. I think we're talking about two different time frames. You're talking about after the adoption. Within this 10-day window.
I'm talking about the amendment. I mean, within
Yeah.
the 10-day window, okay, assuming that's ordinance is fine.
Yes.
So then we have the amendment that comes up later.
Yes.
And the question is whether it's, and the statute says it can be amended. So the question is it a true amendment, or is it a repeal and replace, as counsel argues?
It is, Your Honor, it is not a repeal and a replace. It's an amendment.
What portion of it still is in existence after all these weapons are banned from possession in the village?
Well, all of the structure is there. What was passed in 2013 defined assault weapons. It identified the characteristics that made something an assault weapon. It characterized who all would be covered by this. It covered the safe storage of these weapons, the transportation of these weapons. What changed between 2013 and 2018 was tightening that regulation to say you have to store these outside the village limits now. To address something council said, there's no limitation on ownership. Anyone within Deerfield can own an assault weapon. They just need to store it somewhere else. You're not allowed to use an assault weapon within the village limits. So this is just saying if you're going to go hunting with an assault weapon, if you're going to go target shooting with an assault weapon, that needs to be stored outside the village limits. So it really is a question of possession, not ownership. That's a distinction without a difference. The ownership requiring safe storage of the weapons was a restriction on ownership. You could own it, but you couldn't take it outside, and you had to maintain it in a locked position in 2013. In 2018, you had to do that outside the village. But if I could, the important thing, Your Honor, is the context. What were they discussing when they said amendment here? The critical case, Park Forest versus Wachowski, from 1963 has been the law that this court has laid down for over 50 years, which is let's look at the intent of the body that passed the legislation. What did the municipality want for its ordinance? Was it a complete repeal or was it an amendment? What's the intent? And if you look at all the indicia here, we started from the framework of the 2013 ordinance. We actually did a red line to preserve the critical parts of the 2013 ordinance. We labeled these as amendments. The text describes them as amendments. There's can really be no question that this was intended as an amendment, and that's the critical question that the court has to answer.
Mr. Wilson, then if that's the case, then how should this court assess whether the purported amendment is too radical to constitute an amendment? What is it? What's the test that we're to apply?
I think what you need to look at, Your Honors, is what was in place in 2013. And Cook County and the city of Chicago, that's nearly 40% of the state of Illinois, according to the amicus briefs, had complete bans in place. You could not have an assault weapon in 2013 when they passed this. And I think it's clear that they were trying to make sure we are not trying to revoke the city of Chicago or Cook County ordinances. And then in the Wilson case, just a year prior to adopting these amendments, this court had said that the ordinance did pass certain muster and waited on other issues. But that had been before this court, and that was before the legislature, which is the General Assembly is saying we are not going to undo what the city of Chicago has. So critically, in 2013, when they said this can be amendment, complete bans were okay. So the idea that an initial regulation and then moving to a permissible complete ban is too radical, to use Your Honor's word, it just doesn't withstand logic.
Counsel, doesn't radical mean in relation to the textual and the meaning of the ordinance that was in question? In other words, is this not whether the subject matter is radical, it's whether or not it's a total departure from what was the textual part of the ordinance?
I think there's two things that are important to answering that, Your Honor. One is the 10-day window. There was a fuse lit on every municipality in Illinois, every home rule jurisdiction. You've got 10 days to get something passed or you lose this authority. So they had to operate within that context. Do we pass a definition? I think the municipality amicus called it faux amendments, or a regulation, or do you move all the way to an outright ban? Highland Park, for example, went to an outright ban. Deerfield did something interim. They said we're going to regulate them, we're going to define our authority, but then we're going to allow ourselves to tailor that to what fits. After Las Vegas, after the Marjorie Stoneman Douglas shootings, people in the village said, we need to revisit this, we need to move to a regulation that includes an outright ban. So it's not radical when you take the context of the legislation and the operating environment.
So as long as they mention assault weapons, they can do anything they want after that?
Well, within reason, as any rationality test. But I don't think there was any limit that said, if you just adopt a regulation, you can't go to a ban later. In fact, at the village meetings, that was the issue that was brought by the people opposing the regulation, which is, this is just a stalking horse, and you're going to ban them later. That wasn't the case, but that was the concern. And that's how people interpreted this at the time, which is, you're asserting regulation and you can move to a ban later. But I think an interesting way to look at this is through the other end of the telescope. If the city of Chicago says, we've had a ban in place, but we've had a change of heart and we're moving to a regulation, or we're lifting it all together, as Justice Burke suggested, appellants would say that that's not permitted. That's too radical a departure to go from a ban to a regulation, or from a ban to permitting them, that you're stuck, you're frozen in place from whatever you did in this 10-day window. That simply wasn't the intent of the legislature. If I could, I just want to address the jurisdictional argument, unless Your Honors had questions about the merits. Chief Justice, you asked the right question. What's the harm here? All they're objecting to is we had our appeal heard and we lost. First of all, I want to address a factual matter. We appealed within 30 days. It was the second district that said, we can't tell whether these cases are merged. We can't tell whether you need 304A language or not. We're sending it back down. We went back before Judge Baronis, who said 3 things. First, he granted the 304A language and said you can immediately appeal. Second, he said that order I entered on my own in July of 2018 was a merging of these cases. That's what I intended. They were both test cases. I always intended for them to be brought together. And third, he went on the record to say, and to the extent people are looking at the docket entries, there are 2 docket entries in these cases only because of the limitations of our docket system. If I could have entered a single order for all cases, I would have. But the CRIMS system limits me. And the only reason that was important was because in some cases that went the other way, where they appealed too late and they didn't have 304A language, in trying to glean intent, the court said, let's look at the docket system and see if they were treated as a single case. And he was saying, please don't look at that. Look at my intent. I am giving you my good faith intention, which is I always merged these 2 cases. They should go up on appeal together, and that's what they did. The Second Circuit recognized that. There's absolutely jurisdiction to hear this appeal. What there may not be is jurisdiction to hear that argument, because they didn't appeal Judge Baronis's order. They didn't say, you were wrong, Judge, when you said these cases had merged. So I don't think they have jurisdiction to argue, I'm sorry, they don't have standing to argue a jurisdictional argument based on that order. You can raise jurisdictional arguments at any time, but I don't think you can raise one based on an order that you haven't appealed from. So, Your Honors, when the General Assembly passed its amendments in 2013, it permitted concurrent jurisdiction over assault weapons. City of Chicago, Cook County, any home rule jurisdiction that wanted to adopt a regulation to assert its authority over assault weapons could do so.
Was there anything in the record about Judge Baronis making sure the Easter Day plaintiffs were notified post the decision in their favor on items that went forward with the Gun Save Life?
So on March 22nd of 2019, we received orders in both cases, on summary judgment for Gun Save Life and then a companion order for Easter Day, I think. One was a companion order and one was the same order. We appealed within 30 days of that. The court sent us back down to get 304A language. But at the ruling on September 6th, 2019, as to whether or not the cases had merged, whether or not there was 304A language, the counsel was there and argued at that motion. So yes, they received notice.
Well, his comment was there were things that happened in the interim.
Oh, what I think he was saying, Your Honor, is after I was granted summary judgment or the permanent injunction, I thought I was done, and so I didn't get notice of other hearings. But he was at the September 6th hearing. He received notice of those. So, Your Honors, for all of those reasons, the decision of the Second District was well-founded, well-reasoned, respected most of all home rule jurisdiction and the continuing jurisdiction of municipalities like Deerfield, Chicago, Cook County, Evanston, Skokie, We ask that you affirm the decision of the Second District. Thank you. And if there are any questions? Thanks.
Mr. Siegel?
Thank you. The answer to your question, Justice Burke, is no. We received no notice of anything going on. Yes, we received notice that there was a motion for a merger, but other than that, we received notice of anything. We didn't receive notice of anything because it wasn't our case. It had nothing to do with us after we received summary judgment. Your Honors, the defendant's case regarding the preemption issue is all presumptions. They want you to presume home rule even in the face of Article 7, Section 6H in the statute. They want you to presume an amendment even in the face of the plain language. Now this, I don't know if, is that me? The amicus for the amici for the defendant, it's the same, it really is the same thinking. We're not banning, they're just narrowing possession, except they're narrowing possession from law-abiding residents to only the military and law enforcement, so no one else can have them. One other amicus just said this is just a more comprehensive regulation. It's a more comprehensive regulation by eliminating almost everyone that can have them. The Park Forest case to which the defendant alluded, yeah, they looked at legislative intent, but they looked at legislative intent by looking at the plain language of the statutes involved. That's what was supposed to be done. That's the Hayashi versus IDFPR case that this case decided. The most reliable indicator of legislative intent is the language of the statutes, or in this case, the ordinances. The court in the village knew this because in their own municipal code, they say that a new enactment versus a continuance of an existing ordinance is determined on whether the provisions relate to the same subject matter and are substantially the same. This is the dissent in the appellate court. Yet one day you have a regulation about where you can park your truck, and then the next day you have a regulation banning trucks altogether. Are you going to really say that that second one is an amendment of the parking code? No, of course not. If there is a clear conflict between the two ordinances where both cannot be carried out, then an intention to repeal will be presumed. That's the first district in the Nolan case. I understand that me saying that the Nolan case was binding worked as well as it worked insofar as I was talking to the circuit court or maybe to the appellate court. So I understand that this court is not bound by that, of course, but it certainly is persuasive legal philosophy here. You had one ordinance, now you have another one. Can you carry out the first one in the face of the second? No. Well, then you've repealed the first one. A subsequent statute revising the whole subject matter of a former statute and intended as a substitute for it, even if it doesn't have express words to that effect, operates as a repeal of the former act. That's the Athey versus Peru case. If they took that 2013 ordinance and repealed it, you probably wouldn't be getting much complaint from this side of the table, but you might perhaps from other residents who would be opposed to that. I think that you could take an ordinance that you passed and just repeal it altogether, and legally you'd be allowed to do that under Section 13.1. I don't think that triggers the whole you can amend it or not analysis. I think it's a separate issue. But in terms of what is an amendment and what isn't, there's case law that describes what the difference is. the disingenuousness of the amici notwithstanding for the defendant, what we have here is one day you have something that's allowed and the next day you have something that's prohibited. I'll submit to the court that in no analysis would you consider that a mere amendment. Unless the court has any questions for me, I'll appreciate your time. Thank you.
Mr. Barnes?
Just a few quick points in rebuttal. I think the Chief Justice asked what the test is for distinguishing between a repeal and replace versus an amendment. And my test is it an important change in policy? If it's an important change in policy, then it goes beyond the mere amendment that this statute permits. Mr. Wilson on the other side suggested that Section 13.1 on our reading might prohibit a jurisdiction that has adopted a ban on assault weapons from repealing that ban. I don't think that's correct. That issue isn't before the court, but what I would submit is that when I say that repeal and replace is problematic, it's really the replacing and not the repealing that's problematic, because when you're replacing a prior ordinance with a new one, it's the new ordinance that's preempted. And so I don't think it's necessarily problematic for a jurisdiction that has some sort of assault weapons regulation on the books to repeal it. But when we're talking about replacing existing legislation with new legislation that adopts a new policy, that's when we get into 13.1c preemption.
Mr. Barnes, though, the meaning of the word amendment in Section 3.1 of the Void Card Act, do we use that to determine what the meaning is? Or what should our sources be for determining when is an amendment an amendment? And not something else?
Well, Your Honor, I think that goes straight to the heart of the case. And what I would submit is that we should start with the plain meaning of the word amendment and in common usage. When we talk about amending a statute, it's typically used per Black's Law Dictionary to refer to a relatively minor change to the law. So that's kind of the starting place for the analysis. And then the further step I would take in trying to sort of buttress my understanding of the test for distinguishing an amendment from a repeal and replace is the context here. And as I mentioned in my opening remarks, the key point here is that the ordinance the statute, Section 13.1c, focuses on the ordinance as opposed to particular jurisdictions being exempted from the force of preemption. And so those are kind of the two textual hooks I would submit for using a substantive test for distinguishing amendments from repeals and replace. And finally, I think it's worth maybe taking a step back and thinking about the underlying policy that the legislature was trying to adopt when it enacted the statutory text. And on Deerfield's reading of the statute, it just totally elevates form over substance. And you know, because Deerfield used the magic word amendment, because it retains some of the structure of its prior enactment, because it retains some of the definitions from its prior enactment, that just answers the question. And the problem with that reading of the statute is that it makes the statute almost incoherent. I mean, what is the point? Why did the General Assembly care whether Deerfield used this word amendment as opposed to officially enacting a new ordinance adopting the same policy? Our reading gives kind of a coherent policy rationale to this statute, which is basically what the General Assembly is telling us is, okay, we're going to shut down further regulation going forward by local government of assault weapons, but we're going to allow the existing laws that local jurisdictions have adopted within this 10-day window to stay in place. And we're going to give jurisdictions some limited authority to make modest changes to their existing laws. So let's say somebody develops a new firearm that it evades the definition of assault weapon that's in Deerfield's ordinance, but nevertheless, on any reasonable metric, belongs in that category. Well, that's the kind of situation where the General Assembly is telling us, okay, Deerfield can amend, make a modest change to the lengthy list of firearms that it's identified in its definition of assault weapons to add that new firearm to the list. That would be a reasonable amendment. That's not what we have here. Instead, what we have is an important policy change, a very significant policy change, where we go from modest restrictions on the way these firearms can be transported and stored to an across-the-board ban on ownership. And that is the kind of important policy change that can't be fairly characterized as an amendment under this statute. So with all of those, for all those reasons, I would just urge the court to reverse the second district.
Thank you, Mr. Barnes. Cases number 126840, 126849, Guns Save Life et al. Versus the Village of Deerfield et al. These cases, known as agenda number 21, will be taken under advisement by the court. Thank you, Mr. Siegel, thank you, Mr. Barnes, and thank you, Mr. Wilson, for your oral arguments this afternoon.